One thing I haven't seen addressed enough in the post-Loper Bright space, where the Supreme Court overruled the Chevron doctrine granting administrative deference to government agencies, is the effect that the Loper Bright decision is likely to have on companies in the emerging technology space, the digital asset space, or AI. Companies in this space, especially ones that are either just starting out or looking to launch their US operations for the first time, are desperate for regulatory clarity. All of our clients in the On-Chain group that I've talked about this issue universally said the framework in the EU is preferable because it is so specific and provides so much detailed guidance on how to comply. It lays out regulatory expectations so that if a company really does honestly want to comply with the law, it doesn't end up getting dinged on the back end for not being able to read the regulator's mind. In the US, federal regulators have been slightly more reluctant to issue that kind of guidance in the digital asset space, but state regulators have done so, in particular the NYDFS, where I used to work. I think that the type of specific, detailed guidance that state regulators have offered in the digital asset space, for example, the NYDFS, both with regard to transaction monitoring, cybersecurity, and digital assets provisions, is going to be a thing of the past. So I think that regulatory bodies are going to be very hesitant to issue specific guidance when they know that that guidance is going to be subject to scrutiny by the courts, and perhaps the courts are going to think that the agency has read too much into the underlying statute because statutes passed by Congress tend to be broader and less specific in the steps that they require to comply with the law.